Until January of this year, January 14, the term rescission had never been defined by the Illinois Supreme Court. There were different variations of ideas of what that meant. On January 14, 2014, the Illinois Supreme Court released this decision in People v. Elliott, 2014 IL 115308. They redefined the term rescission and its implications with respect to driving while license suspended. In Elliott, the defendant was charged with driving while suspended 6 days prior to a summary suspension hearing and eventually was rescinded. The court held that a subsequent rescission of summary suspension did not render the charge invalid. At the time he was arrested, there was a statutory summary suspension in effect, and just because it was rescinded on a later date did not go back retroactively to that date and void out the arrest. So what the Supreme Court said was that the term rescission carries a prospective meaning and not a retroactive one. Final thoughts. From the defense standpoint, the prosecution standpoint, prosecutor, know your case, know your police officer. Know the good ones, know who make mistakes, know what you have to do. Read the statute, read the case law, and have it in a trial notebook, because these issues are going to come up time and time again. And if you have them in your trial notebook and you have these cases and you're able to give them to the judge, number one, that's going to help you further your case. Number two, it shows your credibility and believability that you know what you're talking about. So when the cases are close, you're more likely to win with this judge when you have a comfort level. For purposes of some kind of informational books, look at ICL, the Illinois Institute for Continuing Legal Education, the Defending DUI and Related Cases, Chapter 1 and 2. Tommy Moran is the publisher, has a lot of good information on statutory summary suspension and DUI. If you have a question on standardized field sobriety testing, Chapter 6 was drafted by me and gives you some information on standardized field sobriety testing. In closing, the statutory summary suspension law in Illinois has proved to be successful. From the states and the Secretary of State's perspective, 93 to 94% of all suspensions are issued remain in effect, and the goal, as the courts have said, the appellate courts and Supreme Court, is to take those individuals charged with drunk driving off the road immediately. Keep in mind that the statutory summary suspension, even if it remains in effect, is not controlling on the DUI case. Thank you.